As Ask a Lawyer continues, remember that attorneys are standing by to answer your legal questions. All you have to do is call a local or toll-free number found at the bottom of your screen and speak to an attorney about a legal problem for free. Volunteer lawyers who staff our legal hotline find they often encounter similar questions from different callers. Next up, you'll hear some practical legal advice with attorney tips.
One of the most important things you can do as a tenant is to get everything in writing. Your rights don't exist unless they're written down. And when you get a lease, your lease is in writing. When you pay your landlord, ask for a receipt from that landlord. The little stub you get on your money order isn't necessarily going to work in court. If you need repairs, send that list to the landlord in writing. You might call your landlord, discuss it on the phone, but afterwards, send a nice letter about it. Make sure you date it and put it in the mail to the landlord. Keep a copy for yourself. When you get to court one day, you may need these papers.
It is estimated that about 40 to 50% of married couples in the United States divorce. Tulsa attorney Kara Pratt introduces us to two of her clients whose marriage ended with difficult divorces and custody battles.
My ex-wife filed for divorce. I didn't immediately search out for an attorney. I'd never, been to court before for anything, so it was all new experience for me, and I definitely needed advice on what to do.
In Kyle's case, he came to us because he got served with a petition for divorce. So in his scenario, well, what do I do now? So we were able to walk him through the appropriate responsive things to file and what the next steps would be with the custody emergencies. His process was longer because his divorce had things that kept happening with his spouse.
She had actually ended up going into a mental hospital about a week after she filed for divorce. So we had to file for emergency custody initially, which was granted to me. Once she got out of the hospital, that's when she was put on supervised visitations, and that went on for, I think, several months.
Kyle's case probably took a little bit longer because we were dealing with somebody that had some mental health issues on the other side. In a situation where a person is dealing with mental health issues, they're not going to be as with it and ready to do things at milestones like a normal case. They perhaps take longer to adjust to different scenarios and situations.
So having an attorney or seeking advice from an attorney, I think for me it helped a lot. I'm always one that wants to be prepared, and I think they helped me understand what to expect, what to document.
When random things pop up in a case that you weren't expecting, depending on what it is, if it's an emergency custody type of situation, you just really have to stop and focus on that aspect of it and get through that hurdle. Kyle and I had a lot of questions of, I'm sorry that she filed something else and we have to jump over this hurdle now. A lot of reserving attorney's fees, because in situations like that, the court can award a prevailing party attorney's fees or a party that has had to deal with somebody difficult on the other side.
Having someone there that's been through, I'm sure multiple cases similar to mine, gave me ease. Peace of mind. It was always helpful to be able to, if I had a question regarding what to expect, to be able to bounce that off of them.
In the end, we were able to get him sole custody of his children, get him some financial support, and just sever that relationship, which was really what needed to happen for everybody to move on and be able to create new lives and new structure for a family.
She filed for emergency custody at one point, which we defended, and the courts denied it. Eventually, after a year and 8 months, the divorce was final. Getting finalization on the divorce, helped me move on in my life. I'm now remarried. I have 5 kids with my ex-wife. My wife now has 4 kids, so we've got 9 kids together. I like to say we're the Brady Bunch on steroids.
I had been married to my ex-husband for quite some time. He was not a nice man. He was very unkind to me, at times cruel and abusive. I had kind of been raised in a way that it was like, you don't get divorced, you just stay married and do, whatever you can. Initially, I think I just wanted to separate. I still had like a little bit of hope. It is not healthy to stay in an abusive environment or a toxic environment. You're much better on your own, loving, yourself and loving your children fully, because as much as I was loving them and protecting them as much, as I could, and, the harm wasn't being done directly to them, they could still hear things. I remember specifically one night, he became really angry with me and woke me up out of my sleep and was screaming at me and berating me. And he started to choke me. And, I was able to get him, to stop it. I remember just thinking, God, I hope the boys can't hear. I hope they're asleep, And that was one of like just the very, very last straws, I'm not gonna do this anymore.
Bethany was actually the filing party in her case. Her marriage, her history was a little more emotionally traumatic. She had experienced and dealt with abuse. Those cases are different because she was emotionally damaged. She had a lot of wounding, and so I had to help her regain her confidence in herself, regain things that had been lost throughout that marriage, pieces of her.
It was a scary thing. There was a whole lot of unknowns, and she was great. I could call her at any time, email her, ask her any questions. I had dealt with a lot of fear, and I was still, fearful of him and some other things. It was good to have guidance that I needed, and it definitely helped to give me a feeling of security.
Bethany was much more timid when she very first came in to meet with me, and through the course of my representation of her, she got her voice back, she got her confidence back.
One of the things that I went through was a lot of text messages, phone calls, emails, just from him, from my ex-husband. And it was a difficult thing to go through. And I would call her, like, what do I do? What do I say? And she would say, you would tell him to contact his attorney, and his attorney can contact me.
We had to have multiple hearings to even get to a temporary order. So the initial document that governs a divorce is typically the temporary order. In Bethany's case, we were not able to reach an agreed temporary order. We actually had to have hearings. And those hearings were bifurcated over the course of, I think, 3 or 4 days. Because there are so many cases on our dockets, you don't just get to have a 6-hour hearing. But in her case, a hearing of that nature was necessary because the custody was such an issue and Dad was trying to get some of that. So it took a bit longer. Once we finally got that temporary order in place, it was really just a stall on the other side of, now this guy has a child support obligation, now he has an alimony obligation.
I was seeking sole custody of my son, and I got that in every way. Monetarily, it was in my favor as well. For me, I felt like I was just asking for what was fair and what was right, and I definitely got that.
One of the main things that I did was I got her ex-husband on the stand, and I started asking him questions that to me are basic questions, but really solidified the fact for the judge that this guy did not need sole custody because he didn't know where the child went to school. He didn't know who the child's teachers were. He didn't know who the child's pediatrician was. He didn't know the child's schedule. He actually came around and communicated with her that he would like to settle. I drafted a decree that we proposed to them, which was favorable to us, and they agreed to it.
It was a huge weight off my shoulders, just like a big burden lifted, truly gave me more peace. And I would say that I've gotten that afterward as a part of the process of it all being done. And I'm so much more confident than I was before. I truly feel like there's nothing that I cannot handle. There's nothing that can be thrown my way that, I couldn't overcome.
These cases were a little more emotionally charged, number one, because of the abuse in Bethany's case, and number two, because of the mental health issues in Kyle's case. Because the person on the other side was unique, both of those cases were ripe for being an award of attorney's fees in them. An attorney can be helpful in helping a client, especially a client that's been in a difficult marriage, regain some of that confidence to actually say what they want And then also help them navigate through custody hearings, because when you're faced with losing custody of your kids, that's a huge thing. And it is very scary for a lot of people.
I would say having an attorney for this process is definitely of the utmost importance.
Joining us now are three lawyers. Amber Godfrey, whose practice focuses on family law. Allison Dow is former chair of the OBA Family Law Section. And Phil Tucker, also a former chair of the OBA Family Law Section. Welcome. Allison, what can a party in a divorce case do if they feel like their child is not safe with the other person?
If they feel like their child is unsafe, they first need to evaluate, hey, what threat are we talking about? Is this, because safety can be defined in different kind of ways. Is there a threat of abuse? Is this emotional harm? Things like that. I would always recommend getting a child in a counseling situation.
Amber, these cases are always difficult when children are involved. How does the court determine custody?
There are a number of factors that the court can look to. It might be custody in general. What we usually think of is legal custody, who can make the decisions best for children. A lot of times they look at what parent has been the most actively involved in the children's lives, scholastically, medically, with extracurriculars, things like that. And sometimes it's fairly equal when it looks at parenting time or visitation, the physical custody. They might take into consideration bonding between parents, attachment with parents and children. It could be a parent's work schedule. It could be the child's school schedule. So there are a number of factors that the court will look to, and it's all on a case-by-case basis.
Phil, is there a preference in the law for the mother or the father?
No, it used to be that children of tender years went with the mother, and children of an older went with their father to earn a vocation. That hasn't been the law in Oklahoma since 1935. Now there is no preference.
Allison, is there a role for children in divorce cases involving custody?
Absolutely. In Oklahoma, when a child is 12, they can actually state a preference. Now, the court does not have to follow the preference, but they can definitely say, kind of, here's where I want to go and why.
So they can express that. Is someone appointed to represent the children very often?
It depends on what you mean. We can have an attorney for the child who actually represents what the children want to do in the case. It's actually their attorney. That, in my estimation, is not as common in Oklahoma in a typical family law setting. But we can also have a guardian ad litem, which is a fancy Latin phrase that means they represent the children's best interest. It's not necessarily what the children want or even what either parent wants, and it might be a hybrid, but it's kind of looking at the situation as a whole and giving the court some insight, some direction on what would be in the children's best interest, all factors taken into account.
Phil, how is child support calculated?
Well, child support is based upon a statutory formula, and we use a shared income model in Oklahoma where you take the gross income of both parties. That will go to a table. You'll factor the percentages that each party has to that child support amount. You figure in the cost of health insurance and child care, and there's a mathematic formula then that you plug in and you come out with a number.
But that's different from alimony.
That is different from alimony. That is correct.
What happens if one of the parties does not pay?
Well, there are several remedies in place, and that is obviously a pretty common problem. You have income assignments, you have contempt, you have, DHS oftentimes has a collection process that they have available that private attorneys do not.
Allison, what if one of the parties actually makes more than they say they make?
So that is actually hard, especially if a party is self-employed. Proving that income is difficult. And always, the other side is going to say, he gets cash, find it. And that's a challenge.
Amber, can that support and can custody be modified?
Absolutely. Actually, spousal support, child support, custody, and visitation or parenting time is always modifiable so long as the issue is still in front of the judge, meaning the children haven't aged out, turned 18, graduated high school, the support alimony has not already expired, so to speak. It's always modifiable, specifically to child support. If what Phil Tucker was just saying, the income of either parents, the health insurance, or child care changes in any capacity, which health insurance changes pretty much every January. Daycare sometimes falls off. Kids get older. And anytime one of those events occurs, a parent has the right to ask the court for a modification.
And Phil, what triggers modification of custody?
Well, you have to have, it's called the Gibbons test in your traditional sole custody arrangement, which is a permanent, material, and substantial change of condition in the parent's home that negatively impacts the child, so that the child would be substantially better off in the non-custodial parent's home.
So that is the standard that the courts will apply across the board?
That is in a sole custody arrangement. That is correct.
All right. Thank you very much for discussing family law with us on Ask a Lawyer. Amber Godfrey, Allison Dow, and Phil Tucker. Thank you.
Thank you.